You all can feel free to take the tables. We got a few more minutes before we start.
Is that someone in your office with the speed racer?
I am that person, but someone may have we all have one account. So when we log in, that's, well, I should put differently. That's someone on my staff, represented by that icon. I'm the one who inflicted that on the icon.
No, some of us who actually know who speed racer is, I'm afraid.
It's generational. Only if you need to. Gotcha. The back, right there. Right there. Oh, who's this in the back?
Oh, that's my friend's down
Oh, okay. He's not going to testify. She's just here for moral support. Yes. Okay. You know. All right. Are you ready? Was that yes? Yes. Yes. Okay, great. All right, well, let's get on the record in 25CV006709. Make sure the equipment is working here. It is. Hold on one second. Technical problem here. There we go. All right, which is Rutherford versus E3, Pym, and Robinson. And we are going to be talking about the motion for preliminary injunction filed by the plaintiff. It would help me if I could get the appearances for all the parties. And I'm gonna give you my understanding of where we are and what's going on. And you can say, you got the wrong case, and get me otherwise up to speed. And then we can talk about the parties' positions on that motion for a preliminary injunction. So who do we have here for plaintiff Rutherford?
Morning, Your Honor. Don Swift and Justin Edge, and Justin will be taking the lead today. I'll be helping some witnesses.
All right, well, good morning, Mr. Edge. And is this Ms. Rutherford?
Yes, sir.
Mr.
All right.
Rutherford.
Great, good morning.
Good morning.
And who is here for E3?
Good morning, Your Honor. Knox Withers and Kelsey O'Neill for defendants E32 LLC and also Cameron Pym. We have Mr. Pym joining us remotely. He lives in Nevada, as well as one of his business partners, Andrew Pinckney. They're both on Zoom.
Got it. And Mr. Withers, will you be doing the talking or Ms. O'Neill?
We're going to both do some.
That's fine. It works however you want to do it. And then we've got defendant Robinson, and I guess his lawyer chose not to be here in person. Mr. Kenner, you out there?
Good morning, Your Honor. Robert Kerr on behalf of Bobby Robertson, the
All right.
defendant in this case. And she is appearing by Zoom as well, Your Honor.
All right. I'm going to add you to the screen there so that we can see you. We'll get the podium. All right. So Ms. Robinson is on the call. Mr. Pym is. We've got Mr. Bonus business partner on. So I think we've got everything. Okay, great. So Ms. Rutherford and Ms. Robinson were in business together, owning and operating Harold's Chicken and Ice on Edgewood, which is now closed. There is lots of haze around what led to the closure and what was going to happen after it was refurbished, and was Mr. Pym brought in as a partner, or did he force someone out? And someday we'll get to the bottom of that. But Ms. Rutherford, through counsel, has filed this motion to try to freeze things, freeze accounts, no more spending, things like that. And I'm going to let Mr. Edge talk us through what the concerns are, in particular, what the irreparable harm would be if we don't freeze things and what freezing means. And then I'll certainly hear from counsel for the two defendants, if you will. I understand it's more than two, but the two groups on the other side, and we'll go from there. So, Mr. Edge.
Good morning.
Good morning.
My name is Justin Edge, along with my co-counsel, Don Swift. And as you have stated, we represent the plaintiff, Taryn Rutherford, in this instant matter. We are here today seeking a preliminary injunction to prevent defendants Bobby Robinson, E32 LLC, and Cameron Pym from continuing their harmful, disruptive, and infringing conduct against Taryn Rutherford and Harold's Enterprise. And the facts are set out in our verified complaint. Ms. Rutherford is here to explain the facts further. Nonetheless, I'll set out a summary of the facts if the court cares to hear.
Sure.
Okay. This case involves two business partners, Taryn Rutherford, Bobby Robinson. Rutherford and Robinson owned and operated the Harold's Chicken franchise in Atlanta, Georgia, Harold's Chicken and Ice Bar. The pair opened the restaurant in June of 2012. After entering into a franchise agreement with the franchisor, Harold's Chicken Corporate.
And E3's connection is that's the landlord. So there's a piece of real estate, and that's E3. Mr. Pym is the controlling or the only member, but his connection to E3 is that he's basically in charge of E3.
E32 is the landlord at the address 349 Edgewood Avenue.
Okay.
And that's what was the agreement with Harold's Chicken Corp. And
for a bunch of years, everything was fine.
Bunch of years, everything was fine.
All right. So let's fast forward to when it wasn't fine.
Right. So there was a disagreement, or there were several disagreements in the business partnership after learning of the disagreements in the business partnership.
And was the partnership 50-50? Right down the middle?
Right down the middle, 50-50. That was the agreement. Cameron Pym offered to purchase Taryn Rutherford's interest, and Rutherford accepted the offer.
Is that offer in writing, or that's going to be people saying we had a conversation?
It was an LOI. Not sure if that's like an official writing, but there was.
I mean, if there's a letter of intent, that's a piece of paper. So there's a piece of paper that says I, Cameron Pym, or E32, we are offering to buy Ms. Rutherford's share in the business.
Yes, sir.
Okay.
We have a letter of intent. And the pair further agreed to fulfill their individual obligations.
Was the LOI, I know I'm interrupting you a lot, but it helps me understand before you get too far from it. So I apologize if I'm seeming that way. The LOI was from Mr. Pym, or it was from E3 and has to come from a person signs it or as you interact with. But was it Pym individually? Hey, I'm interested in getting in this line of work. I'll buy you out, or Pym speaking on behalf of E3?
Well, it said Pym, it was his signature, and it said manager of E3 too. So
Okay.
I would assume E3 too.
All right.
Or Pym, and we can figure that out. But despite fulfilling her share of the obligations, Pym,
Was the letter a surprise to your client? Where'd this come from? Or, yeah, the LOI, was that a surprise or it was a natural? I mean, it's good because I'm looking to get out.
This was ongoing communication. So he approached her and said, hey, I know you're having these disagreements. I will purchase your interest. I will give you X amount of money for your interest. They negotiated the terms, negotiated the price.
$450,000.
It ended up being $450,000. But then there was conversations with Miss Rutherford concerning an SBA loan and about the change of ownership, right? So she ended up getting the approval. She informed Cameron Pym. They were days or weeks away from the closing table, and then Pym revokes his offer. And interestingly, shortly after Pym revoked his offer, Bobby Robinson tells Rutherford that the business needed to close because of financial hardship. Taryn objected to the closure of the restaurant because the business was not insolvent. And so immediately thereafter, Robinson notifies Rutherford that E32 filed a dispossessory complaint against Harold's Enterprise.
Had rent been paid?
Not at that moment. Rent hadn't been paid, but the parties engaged in conversations regarding what was the next steps were going to be.
Parties means whom?
Bobby Robinson and Taryn Rutherford. Taryn Rutherford.
They talked amongst themselves or they spoke with E3?
They talked about it amongst themselves.
But still rent hadn't been paid?
Not at that moment. No, sir.
So when the dispossessory occurred, even if it may have been some conspiring behind the scenes, was it facially a valid dispossessory? Hey, you're under a contractual obligation to pay rent. You didn't. I can go to magistrate court and get you evicted.
At that point, since rent wasn't paid, yes, sir.
Okay, and I appreciate there may be evidence that this was some collaboration between Ms. Robinson and E3 to get the dispossessory, but in truth and in fact, the rent had not been paid.
The rent had not been paid at that moment. Yes.
Did Ms. Rutherford have the ability to pay the rent? By which I mean not in her own pocket, did she have that money, but did she have the authority to stroke a check from the business's account or electronically transfer from the business's account rent to E3?
Well, they're 50-50, right? And so Ms. Rutherford can't just make a decision on behalf of the business without consulting with the business partner. So Ms. Rutherford told Ms. Robinson, hey, let's discuss a payment plan with the landlord. Ms. Robinson didn't want that.
So for the first bunch of years when everything was working just fine, every time it was time to pay rent, Ms. Rutherford or Ms. Robinson had to ask the other, hey, it's time to pay rent. Do I have your blessing to pay rent? Or, hey, we're equal. Either one of us can electronically transfer money to pay for more chicken, for more ice, for more liquor. Or every time they were going to spend a nickel or more, had to sit down and do you agree to this? I agree. You sign the check. I'll sign the check. I bet that's not how it worked.
No, sir, but there's a general understanding, right? First of the month, rent. But when you're comparing former years to comparing at this very moment, a lot had transpired. A lot of things was murky during this period of time. And so at this juncture, there was maybe over communication just because of things that had transpired. Okay. Right. And so Ms. Rutherford tells Ms. Robinson, well, let's work out a deal with the landlord because our business have seen the highs and lows, right? Ebbs and flows like any other business. And so Ms. Robinson was adamant that no, the business needs to close. The business needs to close. And so a dispossessory complaint was filed. Ms. Robinson tells Ms. Rutherford, we're going to close this business at the end of the year. Thereafter, Taryn Rutherford engaged in conversations with Cameron Pym regarding the transfer of her ownership interest in Harold's Enterprise.
Was the need to close as you would characterize, your client would characterize it? Ms. Robinson is saying we need to close it as in is dead, we need to walk away? Or I thought at some point there was, well, we need to close because we need to refurbish the building, and Pim has said, I'll do the refurb as you guys emerge from the closure as not Harold's Chicken anymore, but as whatever the new thing is.
To close for renovations, but not to close the business for good.
Right.
And she never agreed to that. Renovations were going to be done, but Harold's Enterprise was going to remain on the premises there.
Okay.
But and we'll discuss this further of things that led to this point. But Taryn and Cameron Pym, they're engaged in conversations, and the transfer of her ownership was predicated upon certain conditions. And after acknowledging Rutherford's conditions, Pym agreed to submit a formal writing prepared by his attorneys over the holidays. However, Pym never submitted a formal writing, and he never met the conditions provided by Taryn Robinson. Next, Bobby Robinson closes Harold's Chicken and Ice Bar on December 31st, despite Rutherford's objection, and broadcasting the closing of Harold's Chicken and Ice Bar on the company's social media page. There, Bobby Robinson informed the public that Harold's would be reopening under new management and new remodel. Bobby Robinson also removed Rutherford's access from Harold's bank account, emails, the Harold's GroupMe text message thread regarding the financial and audit information for Harold's Chicken and Ice Bar. And Rutherford further learned that Bobby Robinson and Cameron Pym were reopening Harold's Chicken and Ice Bar in the same location under their management. And most recently, Rutherford learned through defendant's motion that Robinson had allegedly surrendered the lease to Cameron Pym and terminated Harold's Enterprise after being notified that plaintiff was filing this instant lawsuit and this motion for preliminary injunction. And so today, we would demonstrate through evidence that defendants are attempting to reopen an identical Harold's Chicken and Ice Bar in the same location that they're alleging Harold's Enterprise struggle. The defendants are using Taryn Rutherford and Harold's Enterprise's goodwill, social media account, employees, furnishments, and fixtures to reopen Harold's Chicken and Ice Bar. That defendant Robinson has unwinded Harold's Enterprise without the consent of Rutherford. Defendant Robinson surrendered the premises to the landlord without the authorization of Taryn Rutherford. Defendant Robinson has removed Taryn Rutherford her access to Harold's bank account, the GroupMe concerning all of the critical information concerning the business, and emails, and has refused to turn over Harold's books, records, emails to Taryn Rutherford despite her repeated attempts. That defendants Pym and E32 have sued Taryn Rutherford for hundreds of thousands of dollars for a lease that they're alleging that the company surrendered, and that defendant Robinson created a new company during her partnership with Taryn Rutherford and has filed, and my apologies, and has terminated the business after being notified of this lawsuit and motion for injunction.
You said one thing that confuses me, and I haven't seen in the record. I think you said that Ms. Robinson has now sued Ms. Rutherford for hundreds of thousands of dollars.
No, sir. E32 and Cameron Pym have
sued Ms. Rutherford.
So there is a counterclaim.
In this case, there's not a separate action somewhere else. It's the counterclaim in this case.
My apologies.
Okay.
It's a counterclaim.
Yes, I'm aware of the counterclaim.
Right.
Okay. All right.
And so your Honor.
Let's say I agree with everything you say. Like, you know what? I know there are two sides to the story, but the compelling story is Ms. Rutherford's, and that's the one that the facts seem to support. How are we in a space where this is not a money damages claim that you've got? So that if we go to trial or you get a motion for summary judgment after we do some discovery, it is clear that Pym took some steps he shouldn't, and Robinson improperly froze Rutherford out, and you follow the trail of money, and I'm making it up. Ms. Rutherford is either, they still should be in business, although there's nothing that says Robinson can't walk away from a business with Rutherford, but it all seems like it can be monetized. And if it can be monetized, then why are we talking about enjoining something?
Well, Your Honor, I don't think money can cure the damage here. And through our request, we're requesting a narrow set of relief. I mean, there are assets that are lingering. There's fixtures. There are things that belong to Harold's enterprise that have been raided by the defendant. And the most valuable asset here is to right to operate Harold's Chicken and Ice Bar at this location through the franchise agreement with Harold's Chicken Corp. And there's an affidavit that's been filed. I mean, it clearly lays out everything what we're saying here. So money damages cannot cure Ms. Rutherford's harm here. Her goodwill, that the years that she's invested into this company, making it a success in the Metro Atlanta area, her reputation, things that have been said about Ms. Rutherford through Ms. Robinson, throughout the community here.
But the injunction isn't, don't say bad things about Ms. Rutherford anymore. People are free to say what they want, and maybe there's a defamation claim. And if it turns out that Ms. Rutherford was wrongly deprived of her 50% stake, and Harold's presses forward with its business and it's making $1 million a month, why wouldn't the remedy be, if proven, hey, 50% of those profits are owed to Ms. Rutherford because she was wrongly frozen out of the business?
Because it's the assets, it's what she is entitled to here. And it's not the money, but the defendants are—
I'm assuming it's actually the money. It's not, oh, I really miss spending time with Ms. Robinson, and I want you to order Ms. Robinson to spend time with me again. I mean, it's not, it's in the end, it's the money. It's the value of the business. If you talk about fixtures and assets, but if there is a fancy set of bar stools that are worth $50,000, they're worth $50,000. And if Ms. Rutherford properly has a 50% stake in that and they've disappeared, then $25,000 gets her half of those bar stools. So I need you to identify a non-monetary situation here that we're talking about that would say, all right, we need to freeze things. In fact, we ought to have no business go forward, which means no one makes money. And if Ms. Rutherford had a stake in a business, or I were to determine that she has an ongoing stake for which she was wrongfully deprived, she's kind of shooting herself in the foot by saying, don't have the business go forward, because it won't be making any money. And we'll just be talking about who owes what to whom based on history and not this ongoing enterprise.
Right, Your Honor. I mean, this business has been, stolen right from under her feet. I mean, that is the harm, the ability to operate at this premises. I mean, money can't change the months that she has not been able to operate there. And so being able to have this injunction to allow us to engage into the discovery to really prove this case until the final trial, I think is necessary here. Like we need to be able to take depositions, to identify key witnesses, to be able to prove our case and to allow them to open up Harold's Chicken and Ice Bar at this premises as if like there's nothing that they have done wrong. I mean, that's irreparable harm here. I mean, we are allowing them to move forward with their plan after stealing a business from a business partner that actually cared about the business. I mean, that's the harm.
So,
money can't change that. So
then you said it's narrow. Articulate for me as clearly as you can the things you would want me to enjoin and freeze. Because, of course, it's maintaining the status quo. And the status quo right now is that Ms. Rutherford's on the outside and shouldn't be, according to your claims. But that wouldn't be maintaining the status quo if I said you're now back on the inside. But walk me through, with as much specificity as you can, the steps you'd want me to take in an order that would say, all right, you know what, here's what you need to stop doing, Mr. Pym or Ms. Robinson, or here's what you need to hand over, or here's what equitably, it's an order directing people to do or refrain from doing something. What are those things?
And Ms. Rutherford can testify to all the assets that that belong to Harold's Enterprise. So it would to stop them from using the assets that will be identified at a later time by Ms. Rutherford, stop them from spending money that may have belonged to Harold's Enterprise. There were a moment in time where money was transferred to a separate account to be able to stop using the social media page to publicize the opening of this new restaurant, from disposing any of the assets that belong to Harold's Enterprise, and more importantly, to stop the defendants from managing, operating, and reopening Harold's Chicken and Ice Bar on the premises, and to enjoin the defendants from dispossessing Harold's Enterprise from the premises.
Okay, so let's go through those again, because
Sure.
some of them sounded like, hey, money, money, money. And you're telling me this is something that's non-monetary and damn, like an asset. Go back to these bar stools. If for some reason you're able to, phrase it differently, if you're able to demonstrate down the road that Ms. Robinson, in collaboration with Mr. Pym and Mr. Pinkney, sold these bar stools that were the property of Harold's Chicken, which means 50% of it was Ms. Rutherford's. How is the relief not 50% of what they were sold for?
I'm sorry, Your Honor, can you repeat that for me?
I'm trying to wrap my arms around the relief you're seeking, and then understanding how that is appropriate, equitable relief, because failing to do that creates irreparable harm. Right. And you've several times said, well, assets, and Ms. Rutherford can tell you about the assets. I don't really need to hear about the assets. I'm willing to do that, but I'm just using bar stools as an example, a fictional example.
Yeah,
those assets, let's say those assets disappear. You're able to document that the business had these nice bar stools and they're not there anymore. If the business had bar stools and they were sold for $100,000, the remedy for Ms. Rutherford is $50,000, half of the value of the bar stools. She's made whole that way. There may be sadness because they were special bar stools, but the market valued them at $100,000.
Well,
and so the relief would be, hey, Pym and Robinson, here's a judgment against you, and you owe Ms. Rutherford $50,000. I know I'm simplifying it. But I'm trying to extrapolate out to what you're describing, and it all sounds like in the end, it's monetizable. And then we aren't in the right space if we're talking about equitable relief.
Well, Your Honor, I mean, there's open lines of credit, there's credit cards, there's things that are in her name. The Comcast bill is in her name. Deep fryers, everything that's inside of that company, everything that has made the company what it is, that is irreparable harm that money can't satisfy. Like money can't cure that. Money can't cure it. Money can't cure everything that they're receiving from the hard work of that Miss Rutherford has created, and more of the name of Harold's Chicken and Ice Bar. Harold's Chicken and Ice Bar was birthed from Miss Rutherford and Miss Robinson, and we'll get to that during testimony.
Well, in truth, isn't it like saying McDonald's was birthed by the franchise? Harold's Chicken and Ice existed before and independent of Ms. Rutherford and Ms. Robinson.
It was Harold's Chicken Corp. They created this species of this name of Harold's Chicken and Ice Bar that is only here in Metro Atlanta, Georgia. When people hear the name Harold's Chicken and Ice Bar, they think of Bobby Robinson and Taryn Rutherford.
So only the Harold's Chicken on Edgewood was Harold's Chicken and Ice Bar, there are other Harold Chicken in the Metro Atlanta area.
That's the flagship. That was the very first one. Everyone thinks of Edgewood. And so but
if I go to another one, on Panola, wherever there's another one, is it also called Harold's Chicken and Ice Bar?
It is called Harold's Chicken and Ice Bar, and it is owned by Taryn Rutherford.
All the other ones are?
No, so there are some that are owned by Bobby Robinson. There are some that are owned by Taryn Rutherford, but the flagship restaurant is Harold's Chicken and Ice Bar on Edgewood. It was birthed out of that, and the franchisor gave them the exclusive right to use that.
Okay. And so the others in the Metro Atlanta area are all owned by either your client or Mr. Kenner's client?
Yes, sir.
I didn't realize that. And this was the one that they co-owned and co-operated.
Yes, sir.
Not that they cooperated, but they both operated it. All the others they're either a Rutherford version or a Robinson version.
But it belonged to the two of them.
The name.
The exclusive right to operate Harold's Chicken and Ice Bar.
If I reached out to Harold of Harold's Chicken to say, hey, I'd like to open one up and I want to do this Harold's Chicken and Ice Bar thing, Harold would have to say, that's exclusive to Rutherford and Robinson. If I go up to Woodstock, like, hey, it's a little bit outside of Metro Atlanta, I want to open one of these up. I couldn't do Harold's Chicken and Ice Bar. That's sort of a spin-off.
I mean, you would have to seek permission, but for the
permission from Ms. Rutherford and Ms. Robinson, not from Harold.
From the franchisor, from Ms. Kristen Diane Pierce. And she is the president and CEO. And we have an affidavit from Ms. Pierce. But exclusively to operate on Edgewood, she gave them that express right.
Okay.
Yes, sir.
Keep going.
And so, as mentioned, that is the narrow set of relief that we are seeking and that we plan to put forth live testimony today.
Okay. How much time were you told we have? Because you've referred to lots of testimony. How long did you think this hearing was going to go?
I'm not certain. I'm not sure.
Okay.
We
weren't,
got just a couple of witnesses.
Yeah, just a couple
few
of
questions. I mean,
Okay.
the court doesn't want to hear live testimony, obviously.
Well, I don't ever want to say no to that if that's what you want to do. I had this set down for an hour. And so I wanted to hear from the other sides. But we can, if there is something that you think is important to make a record of, in other words, get some evidence in, I don't want to preclude you from doing that. We can go up until just before 11. And then I have my next hearing. I certainly need to hear from the other side, but I was going to have more questions for you than anyone anyway. Lucky you. So I'll defer to you. If you want to put a little evidence up, you should do that. Or you may want to wait until I hear some of the argument from the other side, because I'll always come back to you in the end as the movement to say, is there anything else? And you know what? You need to hear from Ms. Rutherford about X and Y because she'll clear this up. But then, of course, if she testifies, I would need to let Mr. Kenner put Ms. Robinson up if she wants to. And we may be able to fit all that in. So I'm going to defer to you because it's your presentation.
Sure. Yes, our plan was to.
We'll talk and figure out what we need.
Okay. All right. Well, why don't I hear a little bit from Mr. Withers or Ms. O'Neill from E3's perspective, and then certainly from Mr. Kenner, and we'll make a plan.
Thank you, Your Honor. Again, Knox Withers and Kelsey O'Neill. Just to, I don't have additional.
Do you mind? It's not your job so much, but I'm going to ask you to move that monitor a little bit. If you'll turn it that way, because then Mr. Kenner can see you. And now move back to the podium.
Thank you.
Excellent. All right.
Great.
Thank you. IT guy as well.
So, Your Honor, we don't dispute generally that there was a business relationship between these two ladies. They had a falling out and that they didn't pay the rent, and that now, you know, my client and Ms. Robinson are working to salvage the business. We don't dispute that. But I do want to address a couple of points that counsel made. First of all, there was an LOI. It was also terminable. And
I didn't hear him say otherwise. He simply said that your client revoked it.
Right.
And
That's my client.
not that that was a legally improper thing to do, just that Ms. Rutherford had taken certain steps, applied for the SBA loan, whatever it was, and then all of a sudden the rug got pulled out from underneath her, which might not be a tort or a legal wrong, but not maybe the best way to do business. But
Sure.
we're not here because people are bad business people.
Right. And Mr. Pym can explain that. Your Honor asked the question, well, had rent been paid at that time? He said, no, it had not been paid at that time. And in fact, it has not been paid ever since then. So I think.
But how would Ms. Rutherford be paying rent nowadays if in fact, and this isn't your client, but what she is alleging is that Ms. Robinson has effectively shut her out of the business side of the business. And so Ms. Rutherford might desperately want to be paying rent from corporate funds, not from her own money. And she don't have access to those accounts anymore, or that account's now empty because the money got moved to a different account. Not your problem directly, but maybe it hasn't been paid. I guess a polite "so what" is my response as to plaintiff. If all her other allegations are true, gosh, why doesn't your client look to his new business partner, Ms. Robinson, about paying the rent since she controls the accounts?
Well, my client's business relationship with Ms. Robinson is not Harold's enterprise. Okay, so to say we wrongfully dispossessed Harold's when Harold's hasn't paid the rent. And again, you asked me a polite "so what." I think my client would say, get to the two of them a polite "so what." I need to be paid for the rent. I own this property, and the reason I own this property is to receive rental payments from. They're both guarantors, so I from whichever of you, but we need to be paid the rent. But
When was the last time rent was paid? November of 24?
I will defer when we get to Mr. Pym, but it was either in November of 24, or there may have been a partial payment of rent in December of 24.
Okay, but here we are in August of 25 and no rent's been paid.
That's correct, Your Honor. There was this notion that Mr. Pym was going to just over the holidays magically pull everything necessary to do this buyout of this very hugely successful restaurant. That's not something that can be done overnight. It takes months. It takes loans. It takes lawyers. It takes negotiations. And my client did ultimately, I believe it was shortly before this complaint was filed, I believe, informed Ms. Rutherford, okay, we finally got everything to go. Give me this information so we can get you off this Amex bill and the Wells Fargo and so forth. But it was not something that was realistically capable of being done lickety split. Regarding the counterclaim, we can talk about that later. I would just like to note that it is a compulsory counterclaim, so we did have to file it. So that's why we filed it. And then the notion that Miss Rutherford, poured blood, sweat, tears, years into this business, and it's being yanked out from under her. She was paid a salary during all that time. She was paid for the work that she did in that regard, just as Miss Robinson was paid for the work that she did in that regard. So I would respectfully submit to the court that what you heard concretely that Mr. Pym did was he revoked the $450,000 offer, which will explain why. He, on behalf of his company, filed an eviction action where the rent had not been paid. And he is now working to refurbish a restaurant on a piece of property that his company owns so that he can operate a business there. Those are the three things that Mr. Pym and E32 are alleged to have done: revoking an offer, filing an eviction action, renovating a business in a building that he owns.
And when the doors open in, I'm making the date up, October 2025, what's the sign above the doors say?
It is, I believe it's Harold's Ice Bar, I believe. Mr. Pym can answer that question.
But it's not Harold's Chicken and Ice Bar. It's sort of like Coke, but not Coca-Cola. It still has Harold's in it.
I think that's a fair statement. I just
Okay.
I can't tell you the exact name right
My understanding was it was Harold's Ice Bar. So it was like lopping off the chicken. They may still have chicken,
now. Sure.
but no one's going to be confused. Well, actually, it would be trademark confusion. People will think, hey, it's the same place. I don't remember. I thought they had the word chicken in it, but it's the same place, same vibe. This is great. And trading off of the goodwill that was developed for the decade plus as Ms. Rutherford and Ms. Robinson put their sweat equity into it, it will reopen and there'll be that sort of aura of familiarity because the name above it is not going to be McKinnon's. It's going to be Harold's, whether it's chicken or ice. It's come back to us minus Ms. Rutherford.
I believe that's correct. Your
Okay.
Honor. But we would respectfully submit that none of those three things constitute a tort under Georgia law. And, I think Your Honor has, addressed the point already about irreparable harm. We don't believe that the two substantive claims against Mr. Pym, against Mr. Pym, it's just tortious interference.
Right.
Against Mr. Pym and E32, it's aiding and abetting, or
The breach of fiduciary.
aiding, and I'm not sure if that's one claim or three, but that's it. And we do not believe that any of the actions that have been concretely alleged rise to the level of wrongful or improper conduct under Georgia law sufficient to give rise to liability for either of those claims.
Talk to me about the tortious interference. What was the basis there to say there hasn't been a tort? If we take, and I know there's a motion to dismiss pending, we're not working through that today.
Sure.
But if we take at face value the allegations, there is a business relationship between Rutherford and Robinson. And it sure does look peculiar that Rutherford says, well, wait, this is still 50% my business. And yeah, I was in discussions to sell it, but I didn't sell it. In fact, Pym canceled the deal. Perfectly appropriately, allowed to do that. Again, maybe not good business practice if you want to maintain rapport with Ms. Rutherford, but he could walk away. It was revocable. And then magically, a few months later, Robinson and Pym are working together and the place will reopen as sort of Harold's 2.0 minus Ms. Rutherford. Business relationship interfered with, and instead of it being Rutherford and Robinson, it's now Pym and Robinson. So if I'm Rutherford, I'm saying, Pym, well, you interfered with my business relationship with Robinson.
Right.
Tortiously, because I'm out and I've lost money. I have suffered damages.
Sure.
I mean, literally, it seems to fit quite nicely, but I'm sure there's a legal reason. If not.
There's a legal reason and there's a factual reason.
Okay, let's talk about both.
Legal reason is Mr. Pym, neither Mr. Pym nor E32 is a stranger to this business relationship.
Because he's the landlord.
Because he's the landlord, and when they filed their amended complaint, they removed E32 as a perpetrator of this alleged tortious interference and alleged it solely against Mr. Pym so that they could say, well, E32 wasn't a stranger to the business relationship, but Mr. Pym was in his individual capacity a stranger to the business relationship. Of course, you'll hear the testimony, you've heard the argument that Miss Rutherford offered to sell her interest in the business to Mr. Pym. That takes him out of that places him squarely within the ambit of the stranger doctrine. But so that's the legal reasons. Factual reasons, you will see an email that Miss Rutherford sent to Mr. Pym on December 21st of 2024. And, I know we're going to be tight on time, so I'm just going to read the express language to you. She wrote, I am working to gather all relevant information to make the best decision for my personal situation. especially since I have made it clear that I no longer wish to be involved with the business. Mr. Pym responded, I understand. I agree to your proposal for settling the Amex debt and the line of credit. I have discussed this with Bobby and will have a separate agreement with her. He told her exactly what he was going to do. There's no conspiracy. There's no, hiding the ball here. Nothing.
There's at least not a secret conspiracy. He
No,
was very
well,
open
not
about
a
it.
secret conspiracy. There's no cloak and dagger here. She said, I want out. Here's what I expect to do, or I expect you to do if you want my business. He said, we will do it, and I'll have a separate deal with Miss Robinson. And she said, I am in agreement. And there's no tort. It was, I don't know how to explain it any other way, but he wasn't doing anything nefarious or illegal. They had a conversation and then he agreed to it. And she said, I want out.
So to distill your defense / argument as to why equitable relief is not appropriate at this time vis-a-vis your clients is, if Ms. Rutherford has been wronged here financially and beyond, it would be through Ms. Robinson locking her out. Mr. Pym couldn't lock her out, it wasn't his company.
Exactly.
He may be the beneficiary of the steps Robinson took, but it wasn't a secret that he was a suitor of Ms. Robinson, as Ms. Rutherford was signaling very openly, I want out.
I think that's exactly.
And it played out just that way. Lo and behold, look who Robinson ended up going into business with. The very person who was telling Ms. Rutherford, I'm probably going to go into business with Ms. Robinson.
Yeah,
Okay.
that's exactly right, Your Honor. So we, for the factors that the court would consider, we've talked about irreparable harm. I won't waste time on that. I think we've also shown that, as to claims for tortious interference and the conspiracy, what you have right now is Miss Robinson did this, and this. And then in naked conclusory fashion, you have Mr. Pym aided her.
It was his fault too.
Aided her. Right. He had no access to the bank accounts, the email accounts, the text threads, the credit cards. So how did he allegedly do this? And there are no facts alleged in the amended complaint that address that.
Okay, well, you're doing a good job of arguing your motion to dismiss as well, but that's not what we're doing today. All right.
So those are my points. If the court has any further questions for me.
I don't. Thank you.
Thank you.
Were you going to add anything, Ms. O'Neill, or at least at this juncture, you're being very supportive of Mr. Withers?
Exactly, Your Honor.
Okay. All right. Mr. Kenner, you have very patiently and quietly listened to what people have been saying, and
Yes, sir.
even your co-defendant is dumping things in your lap. So your turn. Why is equitable relief not appropriate here? At least to say to Ms. Robinson, wait a minute, you took over these accounts. Anything that's in it is half Ms. Rutherford's property, and it seems to be being spent in other ways in a manner that's not going to benefit Ms. Rutherford because she's not going to be a part of Harold's 2.0. And so we need to stop that until we can get to the bottom of this freeze out that allegedly occurred.
Your Honor, first of all, I think the court was spot on in its analysis regarding the irreparable harm, and that this is simply an issue of damages. There's a lot of smoke and mirrors in this case. At the time that there was a discussion regarding my client and Ms. Rutherford closing the business was insolvent. Business was cash poor. There were discussions.
Cash poor or cash negative?
Cash negative as well as cash poor. And let me just say this, Your Honor, there's written evidence in this case via text messages between my client, Ms. Robinson, and the plaintiff in this case, where my client is discussing with Ms. Rutherford that we need to not take any type of salary because we can't pay the bills. We need to perhaps terminate some employees or cut back on and some of the employees. And Miss Rutherford refused. She refused to. I will say that she did take a pay cut from $6,000, and this was during the. I believe this was during the time when the business was insolvent. She took a pay cut from $6,000 to down to $4,000, but she refused to forego any other type of salary. My client at the time, and this was in December of 2024, as well as in November, was actually pumping money into a failing company. She pumped in over $10,000 to help sustain the company, and Ms. Rutherford refused to do so. There's text messages between the two where Miss Rutherford agreed that the business needed to close. My client even sent a text message to Ms. Rutherford saying that, listen, we need to announce on social media that we're going to be closing because we're not doing well, and perhaps that will help us get some customers in the business and be able to pay the rent. I'm sorry, not pay the rent, but pay the employees, pay off credit cards. And Miss Rutherford agreed. As a matter of fact, she never contest Miss Robinson going on social media saying we're closing. She understood that that this business was going to close. As a matter of fact, in one of the text messages, she said she wanted to have a smooth exodus. So I think counsel for Mr. Pym was spot on as well when he said that she acquiesced in terminating the business as well as winding down the business. And so
So,
this
to tell, I'm trying to understand a little bit well, wait, Pim is going to, I know it's not your client, but I'm interested in your client, which from your side's perspective. It sounds like the financial records would show that this Herald's was in dire straits as 2024 was drawing to a close. And one approach would be, I want to get out of this and maybe I could sell my interest to someone else. So Rutherford trying to sell to Pim. But it sounds like Pim arrived on the scene saying, hey, I'm going to refurbish this building. Was that with an eye towards saving Harold's? I don't know how bad if one of the reasons why it wasn't doing well was because the place had become a dump. Because there hadn't been an investment in keeping the building up, or if it just was, look, it's a restaurant past its prime. Restaurants come and go.
Well, I think it's both. And there was also bad blood between my client and Ms. Rutherford. At some point, my client found out that Ms. Rutherford had removed cases of liquor from the business without Ms. Robinson's consent. And when Ms. Robinson confronted Ms. Rutherford about the taking of the liquor, Ms. Rutherford pretended as if she didn't know who did it. As a matter of fact, my client asked Ms. Rutherford to look at the video or the surveillance video to help her determine who may have taken the items. And Ms. Rutherford said she would. My client spent at least 2 days going over the video, and she saw that it was Ms. Rutherford, and Ms. Rutherford had an excuse as to why she took the property. At that point, the relationship soured between those two.
Okay, so there were financial woes, there were relationship woes, and so that's sort of where we were flowing into the end of last year.
Right, and let me just say this, Your Honor. Towards the end of last year in December, and this is documented through bank records as well, the bank records reflect that there was really no money in the account to sustain, right? The business. The landlord, Mr. Pym, also filed a dispossessory saying that you guys have not paid. So my client, Ms. Robinson, goes to Ms. Rutherford and says, hey, the landlord is going to evict us. What are we going to do? We don't have the money. Ms. Rutherford simply just didn't respond. She didn't care. Her whole thing, her mentality at that point was, I want to exodus from this business. I want out. And so And after the last day, which was December 31st, after the last day when the business closed, in January, I think it was January 6th, Ms. Rutherford removed $2,000 from the bank account. So the court asked, did she have access to the bank account? Did she have to have permission from Ms. Robinson in order to pay the rent? The answer is no. She didn't have to ask for permission because she went into the account. She removed monies from the account at her will. She paid bills at her will. She was not locked out. Secondly, she in January, when she knew that the business was over and that the business closed, she went into the account and took $2,000, which made the account negative. And my client had to put the money back in so that bills can be paid out from December, employees can be paid, and so Ms. Rutherford never put that money back into the account. As of January, there was no more House Enterprise LLC. There was no
When you say no
partnership.
more, meaning it was administratively dissolved through the Secretary of State, or just it's closed? If I went there and knocked on the door, they wouldn't let me in. The business is dead.
Well, it wasn't resolved until I believe it was either March or May through Secretary of State. But
Okay,
there was no more House Enterprise LLC operating the business at that location for as House Chicken and Ice Bar.
got it.
So the business had effectively closed. There
And
was
when you
no
say it was dissolved through the Secretary of State in May or whenever it was this year, how did that come to pass? Is that something that your client did unilaterally?
Yes, my client filed the termination. Well, I wouldn't say unilaterally because well, at this time, she was not speaking. Miss Robertson and Miss Rutherford were not speaking at all.
Right, so
And
she
so,
did it unilaterally. I mean, I understand they weren't speaking, but in the
right,
end, it was Ms. Robinson all by herself who terminated the LLC.
correct.
Okay.
Which Your Honor, she has the right to do because again, there was no operating agreement as to how do you wind down the company, who's involved, who does what, none of that.
You
And
raise an important point that I meant to ask Mr. Edge, and I'll certainly come back to him to see if he wants to amplify on your answer. My understanding is that these business partners of many, many years, it was basically a handshake agreement. There is
correct.
not one reason why we are having to work through this, which I'm happy to do, is that no one can point to paragraph 17 that shows here's what you do. If you want to be bought out, you have to take these 3 steps. And
Correct.
here's what one partner can do without the approval of the other. Any expense below $10,000, either partner can sign a check for that. There may be custom and practice that developed over time, but there is no piece of paper, and it would be more than one, that lays out the operating agreement of the 2 members.
Responsibility.
Okay,
Correct,
got it.
Your Honor. Correct. The other thing that I want to touch on, Your Honor, is that this whole issue of whether the the parties have to get permission from, or someone else has to get permission, a third party has to get permission from either Ms. Rutherford or Ms. Robinson, or perhaps both, in order to open up another Harold's Chicken and Ice Bar, which is not true. The only person that would be able to give consent and give permission would be the owner of Harold's Chicken, and I think it's Harold's Chicken Shack up in Chicago. And so anyone, either if you wanted to open up Harold's Chicken Ice Bar somewhere in the metropolitan area, all you would have to do is contact the franchisor, the owner of Harold's Chicken Shack, and get permission. And so both Ms. Rutherford, from what I understand, she has 4 locations or perhaps 3 locations on her own, House Chicken and Ice Bar, and my client has about 4 or now 3 other locations as well. So it's not true that this idea was just born out of these 2 individuals and no one else could open up a House Chicken and Ice Bar under that name. Um, what happened in this case is that the company, House Enterprise LLC, defaulted on their rent, and they were legally removed from the property. Harold's Enterprise LLC did not own the building. So the landlord had the right to remove them from the premises, which Ms. Rutherford agreed to and did not contest. And so I think, Your Honor, this is a lot of smoke and mirrors on the part of the plaintiff. She does have a remedy at law in terms of damages. And if this case were to go forward, then she can prove her damages that way. I think that what their goal is to try to prevent my client and Mr. Prim from going forward and doing the build out for the business. There aren't any records that my client has in her possession that she is keeping from Ms. Rutherford. As a matter of fact, they share the same accountant. As a matter of fact, they still use the same accountant. So the accountant has all the records. The records are online. There's no more bank account in the name of Harold's Enterprise LLC. There's no more money there. So there's nothing for them to come in and say, we want to prevent them from using that bank account. There's no more bank account. In terms of the equipment, they're not using the equipment. It's not even open. Ms. Rutherford not one time ever sent a letter to anyone saying, hey, I want the equipment, whatever equipment that's in the building. So it's not like they're going to be using the same equipment. They're going to be using different equipment, new equipment. And so I think this is a ploy to prevent these individuals from moving on outside of Ms. Rutherford.
Got it. All right. Thank you, Mr. Kenner. So, Mr. Edge, I return to you as promised. If you think, we've got about 30 minutes left. If you think that there is evidence that you'd get through Ms. Rutherford testifying, we could have her testify for a little bit. I can't let it go too long just in case Mr. Withers or Ms. O'Neill thinks, well, we need to hear from Mr. Pym. Or Mr. Kenner wants to get Ms. Robinson effectively on the stand. It'd be virtual, but we could do that as well. And I saw you conferring. In fact, you even changed seats. So I don't know if you've changed roles as well, but tell me what your plan is.
Yes, we plan to call Ms. Rutherford.
All right, Ms. Rutherford, if you'll come on up to the stand, please.
Our testimony will deal with the truth, our truth, and our purpose of
The chair doesn't have wheels, so it's a little hard to get in, but it prevents you from rolling off, which is a good thing. If you'll move the microphone down towards you, please.
Can you state your name correct?
Taryn Rutherford, T is in Tom, A, R, Y is in yellow, N is in Nancy, Rutherford, R is in red, U, T is in Tom, H, E, R, F is in Franklin, O, R, D.
Ms. Rutherford, who is your 50% business partner?
Bobby Robinson,
What is the name of your partnership's company?
Harold's Enterprise, LLC, DBA, Harold's Chicken and Ice Bar.
How many years have you and Bobby operated the company?
12.5 years.
Do you have the exclusive right to operate Harold's Chicken and Ice Bar at the premises?
Yes,
Which premises that we're talking about? The
Yes, sir.
Edgewood.
349 Edgewood. Who gave you the exclusive right to operate Harold's Chicken and Ice Bar at the premises?
Objection, Your Honor, hearsay. Objection, Your Honor, hearsay.
Who
The objection is hearsay.
is she speaking to something that she knows?
Well, but if she knows it because Fred Smith said, I hereby give you, you're offering it for the truth of the matter asserted, that would seem like would be hearsay.
Well, she's speaking to the agreement that she entered, Your Honor.
She entered into agreement with whom?
Well, I'll rephrase. You.
Okay.
Did you enter into an agreement that gave you the exclusive right to operate Harold's Chicken and Ice Bar?
I entered into an agreement to operate Harold's Chicken and Ice Bar, yes.
And what is the name of the person that gave you the ability to operate Harold's Chicken and Ice Bar?
Kristen Diane Peters,
Who is Kristen Diane Pierce?
the franchisor.
Is this the person in Chicago that Mr. Kenner was referring to?
Yes, sir.
Okay.
Ms. Rutherford, you contend that you and Bobby Robinson are known for Harold's Chicken and Ice Bar in the community.
Absolutely. We are the ones that brought the Girls Chicken Ice Bar brand to Chicago, to Atlanta, Georgia. In Chicago, they're just Girls Chicken shacks. You go in, you order the food, and you walk back out. Her and I were the first to bring it to Atlanta, make it a full-service restaurant with serving alcohol. And because of that, we're a staple of the community. My new location that I opened up, they're like, wow, you're part of the owner of the Edgewood location. And it was like, man, we had some good times.
Objection, Your Honor, hearsay.
Okay.
It's not hearsay.
Well, but so first of all,
I'm sorry.
don't ever rule on someone's objection, not your job. I won't testify for you. You don't rule on the objections.
Yes, sir.
It was hearsay. Let's not talk about what other people said unless it's Ms. Robinson. You can talk about what Ms. Robinson said or what Mr. Pym said, but Joe customer who says you're the greatest and I think this and that, that's what someone else said and you are clearly offering it for the truth of the matter asserted. So when you hear an objection, you need to stop talking.
No further questions, Your Honor.
Okay, appreciate it. Mr. Withers or Ms. O'Neill, do you have any questions for Ms. Rutherford?
Just a few, Your Honor. I'm going to try and really short circuit this. May I approach, Your Honor?
Sure.
I have copies of exhibits with a witness, and we might go through all of those. I'm just going to try and.
And Mr. Edge has a set?
Oh, I'm sorry. Yes.
Yeah, I'm sure he's seen these before, but so he knows what you're talking about. Mr. Kenner, I know you're remote. I will make sure to articulate what specifically Mr. Withers is relying on.
Thank you, Your Honor.
Good morning, Ms. Rutherford.
Mm.
And I'm gonna try and cut out a lot of what I had to ask you, so if there's a little lull in the conversation, let me just indulge me if you would.
We will.
Your disagreement with Ms. Robinson that you've heard talked about today, Mr. Pym was not involved in that disagreement, was he?
No, sir.
Okay, and E32 was not involved in that disagreement, was it?
No, sir.
You allege that in December of 2024, you discovered that Ms. Robinson had transferred funds from the bank account, correct?
Repeat that, please.
Sure. In your amended complaint, you allege that in 2024, you discovered that Ms. Robinson had transferred funds from the Harold's Enterprise operating account to a separate account, correct?
At the end of December, yes, she did.
Okay. And removed your access to the company's bank accounts,
That is correct.
and emails and text threads.
That is correct.
I have a question about that. I understand if Harold's Enterprises had an email account, someone could lock you out of that. The text threads I didn't understand because I think of text like I've got my phone, you've got yours. No one can knock me out of my text threads.
I mean, I'm only speaking on the emails.
Email and bank account.
Yes, sir.
You tried logging in. Hey, it doesn't work anymore. What happened? For both the bank account and the email account.
Let me be clear. I apologize.
That's okay.
The bank accounts, she closed it out. She closed out the bank.
Oh, so it wasn't that you couldn't, they were closed.
Yes.
And so there's nothing to log into.
Yes, the emails, social medias, those are things that she logged me out of.
Okay, where normally you could get online to log something in, log in and you tried, hey, it's me, Rutherford, and you can't get in.
Right,
Okay.
bookings, emails, social medias, anything that had anything to do with Harold's Chicken and Ice Bar, she logged me out of it.
Did you use that social media for your other franchises as well? Or was that account just that social media, just about the Edgewood property?
It was supposed to be just for the Edgewood. I did what I was supposed to do, the right thing, and I did not ever use it except for Edgewood. Ms. Robinson used it for her other locations.
But if you, so if you, Ms. Rutherford, were going to share with your online following that there was someone coming to perform at one of your other addresses, there's a separate social media account for these other ones.
For both of my locations located on Old National and Panola, we used our own platform designed for that location.
Okay.
Neither Mr. Pym nor E32 had any access to that social media account, did they?
No, sir.
And at the risk of getting an objection for a compound question, but in the effort to move this along, neither E32 nor Mr. Pym had access to Harold's bank accounts, credit cards, email accounts, or text accounts, did it?
Everything, I don't know about text accounts, if she showed him text threads, but any of the other information, no.
Okay. If you would turn in your binder there to exhibit PIM 7. Let me know when you've had a chance to look at that.
This is a letter from your firm? I mean, that's what PIM 7 is.
Yes, yes, Your Honor.
Okay.
Okay. You recognize this document, correct?
Yes.
And this is a copy of a December 6, 2024 letter that my law firm, in fact, me, sent to Harold's Enterprise, Ms. Robinson, and yourself, right?
Yes.
And that's your personal email address, taryn.rutherford@yahoo.com, right?
Yes.
That's not a company email address, is it?
No, sir, that is my personal.
Okay. You, in fact, received this letter, correct?
Yes, sir.
Okay. And it's a true and accurate copy of the letter you received?
Yes, sir.
Okay, Your Honor, I'd ask that Exhibit P7 be admitted into evidence.
Any objection, Mr. Edge, to the admission of PIM 7 for the purposes of this hearing only? All right, Mr. Kenner?
No, Your Honor.
All right, PIM 7 is admitted for this hearing, and you'll get a copy to the court reporter when we're
Yes,
done?
We will.
Okay.
This letter advised you that as of December 6th, the tenant, Harold's, had failed to pay rent in the amount of $10,954 and some change, correct?
That is correct.
And that is in fact true, is it not?
That is correct.
Okay. And they demanded that you pay that amount within 10 days, correct?
That is correct.
And neither you nor Ms. Robinson nor Harold's Enterprise paid that amount within 10 days, correct?
That is correct.
Was in your amended complaint, you allege that, or excuse me, I believe in either your testimony or maybe it was your counsel's argument earlier, you said Harold's was not insolvent. Did I understand your testimony correctly?
That's correct.
Was it ever insolvent?
Yeah.
Okay. But
And when we say, I want to make sure I'm following this, you're a very successful business person. You have a bunch of businesses. And so when I'm hearing the question, was Harold's insolvent? I want to make sure we're focused just on Edgewood, not Panola Road, Old National. But what you're saying is, based on your understanding of the financial records of Harold's Edgewood, that's what I'm going to call it. It was not insolvent, meaning it had more assets than liabilities. It was able to pay its bills. It might have been tight, but it wasn't a situation where we cannot pay that bill because there is no money in the bank and our accounts payable are looking a whole lot worse than our accounts receivable.
Okay. That is not a yes or no question. I would like to, is that okay?
Oh, you should answer however you think you should answer.
No, in the past, we've always had, the winter months are always slow. And so last year, her and I both gave up our salary. Okay? So at the time, it was rough patches. This time, it was the same thing. We weren't 2, 3, 4 months behind. We were 1 month. We weren't even a full month. And when I asked about a payment plan, she chastised me. But what she's not saying is that I actually, when she talked about bills needing to be cut, I gave those bills that needed to be cut because her family member was involved. She did not want to agree. I actually showed her where we could cut the monies to $6,000 to where it could get paid. If she would have tried to work with me, then I could have come up with my part and paid the rent. But what she did was, if we were so insolvent, the money that she put in to the business. She made sure she got all of that money back. And then they went and proceeded to that point. So no, the business was never insolvent. Money was still coming in.
Okay,
Yes, sir.
okay, so your testimony is that the business was never insolvent.
Not to close, no, sir, it was not.
But you are aware that in your amended complaint, you have alleged that my clients, Mr. Pym and E32, aided Ms. Robinson in forcing the company into insolvency. You're aware that you've made that allegation?
Absolutely, I meant that.
Okay.
But I just can't talk about it because the judge is saying that is another situation that has to be discussed at a later time.
Okay, that's fine. I'm just trying to understand if it was insolvent, and if it wasn't insolvent, then my client couldn't have forced it into insolvency, but I will move on. If you would turn to Exhibit 8, Pym 8 in your binder there. You recognize this document, correct?
Yes, sir.
This is an email chain between you and Mr. Pym going from December 21st through 22nd, 2024, correct?
Yes, sir.
It's a true and accurate copy of that email, right?
Yes, correct.
Your Honor, I'd ask that, at least for the purposes of this hearing, Exhibit Pym 8 be admitted into evidence.
Any objection, Mr. Edge, to Pym 8 being admitted for this hearing?
No objection.
Any objection, Mr. Kenner? No? All right, Pym
I just want to make
8.
sure, Pym 8 is what is the email thread?
It's an email thread that at the very top, so the last email in the chain, if it's going like it normally does, is one from Ms. Rutherford to Mr. Pym that is dated Sunday, December 22 of last year at 4:49 p.m. That's the last email in the chain. The first is long. I guess there's just an attachment. No, the first is from Ms. Rutherford to Mr. Pym the day before at 2:06. So it's a 3 email chain.
Gotcha.
You got it?
Yes, yes, sir. Thank you.
Okay, 8's admitted.
All right, so Ms. Rutherford, if we look at the bottom email, which is the first chronologically, you wrote to Mr. Pym that you were reaching out to seek clarity regarding the planned renovation for Edgewood because you had not been involved in those discussions. Is that correct?
That is correct.
Okay, so you understood there was a plan to renovate that premises.
Yes, sir, I was involved in it in the very beginning.
And you said you were working to gather all relevant information to make the best decision for your personal situation, especially since you have made it clear that I no longer wish to be involved, especially since I have made it clear that I no longer wish to be involved in the business, correct?
That is correct.
And that's true, isn't it? You no longer wanted to be involved in the business.
Due to the circumstances.
I mean, for whatever reason, but,
So,
and when we say business, it is Harold's Edgewood. Not that I want to sell my other Heralds as well, but the one that you shared with Ms. Robinson at this point in time, hands up, I'm so through with this.
that is how I felt at the moment. I was emotional because she had just sent me a text saying that I think we should just close the business, have a meeting. So I was emotional at that time.
Okay.
Did I want to just outright give it up? No, because I.
Not for free, right?
Well, not even, it wasn't even about the money. I'm sorry. I can't say that.
Mhm.
Sincerely. We started that together, 12 and a half years. That is the reason why all the other locations are doing as well as they are, because we created that brand. And by right, that is the flagship store. It is the baby that started it all. So for me, I was absolutely emotional. I mean, everything was happening so fast from the rent, all of a sudden. Now, we've had business relationships with Cameron for years. Never had an issue, always been able to talk. I had high regard for him. And for 1 month, we can't even make a payment plan, meaning I talked to my partner as I should have, and she didn't want to. Mind you, because they had now a working relationship because they were now about to start a partnership together. I asked her, hey, a payment arrangement. And it became no more. So from that and all these things that happened just in the month of December, within 2 weeks, it was a lot. So yes, I was overwhelmed.
Okay. You never reached out personally to Mr. Pym about a payment plan, did you?
I did not, but Cameron Pym and I did talk about the rent. There were verbal conversations.
In this email, you said you understood the renovations were scheduled to begin in January, right?
Yes, sir, I
And
did.
you understood that the restaurant was set to close at the end of the month.
Yes, but not for the reasons of, because we didn't have the business and so it was because of the fact it was being renovated, because Bobby, Cameron, and I all discussed that the restaurant needed to close at the end of December because Cameron had a arrangement with Pinnacle Bank when he got the original loan that he had to have renovation done by a certain time frame. And because of that, that restaurant had to be closed by the December 31 date.
So the renovations could begin.
Yes, sir.
And in this email, you said you wanted to facilitate a smooth exit, correct?
That is not what I said. The smooth exodus came in the text thread to Bobby Robinson when I was discussing about the bills being cutting the bills.
Okay, if you look down on page 2 of this exhibit PIM 8, You see where-
10?
No, same exhibit, this email chain,
Okay.
page 2 of it. So the second page.
do you see where it says, to facilitate a smooth exit, I would like to propose the following arrangement?
Oh, yes, sir, I did, okay,
Okay.
yes, sir.
You offered to gift your 50% interest in the businesses.
Never again. I proposed.
So let him finish his question, and then you're free to answer any way you want. You can disagree with him, tell him he's a bad man, all that kind of stuff, but let him finish the
Yes, sir.
question.
So let me just read so that there's not any misunderstanding. It says, to facilitate a smooth exit, I would like to propose the following arrangement. Number 1, transfer my interest. I am willing to gift my 50% interest in the business provided that certain conditions were met. That's what you wrote, correct?
Yes, so conditions, yes,
And you wanted him to address your share of the business debt, correct?
that is correct.
American Express bill and the line of credit.
Yes, sir.
You asked to be released from any obligations.
Yes, sir.
Okay.
But that never took place because he never submitted any kind of paperwork. It was just a proposal that I submitted to him. There was no LOI, there was nothing else discussed. Even after the time of December 31, there was one more communication via text thread that he sent to me, and never anything ever came of it.
He did text you in May of,
January 2nd.
he also texted you in May of,
Let him finish the question.
he texted you in May of 2025 saying he had finally gotten all the business paperwork and so forth done that he needed to handle. And he asked you in May, okay, I need you to send me the amounts that I need to pay off. He did text you that, right?
He texted me something similar. I don't have the exact text thread.
Okay.
However, he did text me something, but that was during the time where he knew that I was filing a lawsuit. And he never stated, even in January nor December, that he needed to work out other arrangements, bank, whatever you're stating. He never said that. He never drew up anything because numbers had nothing to do with the fact in just an actual general LOI.
Okay.
Such as how he and I did when he first offered to purchase my 50% interest. We actually talked, discussed, verbal, put it on email, and then it became on paper on an LOI and it was signed, and we moved forward with that. None of that ever took place. It was just a proposed agreement that he agreed to, but it never came to fruition.
But he did text you about it in May, saying he needed some information.
Yes, 4 months later, he did.
And you said that he was aware that you were filing this lawsuit at that time.
Absolutely.
How, until he got served with the lawsuit, how did he know you were filing a lawsuit against him?
His business partner, Bobby Robinson.
And how did?
Of course, that's hearsay, but I'm
Right,
sure.
well, I'm just,
Because of the time.
You can talk about what Robinson says and what Pim says.
Yes, sir. I'm
No, don't apologize. It's new territory for you.
okay. And at least at that time in this email chain, and I'm not saying, I don't want to talk about anything that happened after it, but at least at that time, he said he believed that what you had proposed was an acceptable path forward, and he agreed to you transferring 50% with the understanding that he would have to take on, assume the American Express debt and the line of credit. He told you that at that time, right?
Yes, but what he actually said, he said, thank you for reaching out. I appreciate your concerns and believe you proposed an acceptable path forward. for all involved.
Okay. And he said, I have discussed this with Bobby and we'll have a separate agreement with her, right?
Objection, Your Honor. I mean, this isn't relevant. They're not suing her on the basis of an agreement that was entered in December 21, 2024. So this line of questioning is irrelevant.
Okay.
This doesn't go to the heart of this case.
Well, we're not going to the heart of the case. We're right now here just for this motion for equitable relief, the temporary injunction. You've got about a minute left, because I need to see if Mr. Kenner, has some questions as well. Anything else for Ms. Rutherford?
Give me just a second, Your Honor. But you did understand that because Mr. Penn told you that he had a separate agreement with Bobby, right?
He said that he would talk with Bobby about.
Well, to be clear, what he said was, I have discussed this with Bobby and we'll have a separate agreement with her, correct? And you read that?
Yes, sir. I also stated in May that I retracted any discussions, because that's all it was, a discussion.
You said that in this email?
I said that via text.
She said in May.
Oh, I'm sorry, I didn't hear. Your Honor, that's all the questions I have.
All right. Mr. Kenner, do you have any questions for Ms. Rutherford just about the space we're in right now, which is the equitable relief that's being sought?
Yes, Your Honor. Good morning, Ms. Rutherford.
Good morning.
I want to talk with you about some of the issues raised by your counsel regarding the exclusivity of the name Harold's Chicken and Ice, or Ice Bar. You did not have, you nor Ms. Robinson had a written agreement with the franchisor, did you?
We did not have a written agreement, it was a verbal agreement.
Okay, and you have never had.
Hold on, Mr. Kenner. Let her finish. Keep going.
And in that agreement, we made it binding when we made the payments to her every month.
Well, I understand that.
And we made permission, and we got permission on things that could be on, such as the name Harold's Chicken and Ice Bar. Because it is trademark, we cannot go against anything that she states. So no, it was not an actual written contract, it was a verbal binding contract through payment.
Well, I want to make sure I understand. There's no written agreement or any type of agreement from the franchisor to the franchisee, which would be you and Ms. Robinson for Harold's Chicken and Ice Bar on Edgewood. Is that correct?
Yes, sir.
Okay. And the only agreement that you had with the franchise owner was that you would pay a certain amount of money upfront or at some point after you all open the restaurant on Edgewood. Is that correct?
That is correct.
Okay. And if you yourself or Ms. Robinson independently, or if you all together wanted to open up another Harold's Chicken and Ice Bar, the only agreement would be is that you would have to pay that franchise fee, correct?
Yes, which is an agreement.
Okay. If Ms. Robinson wanted to open up a Harold's Chicken and Ice Bar separate from you, she does not have to go to you for permission to use that name, does she?
No, she has to go to the franchisor.
All right.
So you think I'm sorry to interrupt, but I just want to follow this because it's a little different than you and Ms. Rutherford, you and Ms. Robinson, who were the progenitors of this concept.
Yes, sir.
And you may just not know the answer. If I wanted to open Harold's Chicken and Ice Bar in Woodstock, so I'm getting out of your area, I'm not competing directly with you, I wouldn't ask you for permission to use that name. I would go to the woman in Chicago, Ms. Pierce, and she could say, yeah, you go ahead and use that name. I know some of my friends down there are using it, but I'm the one who can tell you whether you can use it or not.
Yes, because of the Harold's name.
Got it.
Yes, sir.
It's not the ice part, it's the Harold's part. That's the secret sauce.
That's the key right there.
Okay.
And because Bobby and I have actually looked at trademarking, because we were filming at the time years ago, anything that had Chicago, anything with Harold's, anything fish and chicken, they were not allowed.
Okay, so you added the ice bar. I could add Harold's Chicken and Ice Cream, because instead of liquor, you can get a milkshake.
Yes.
More family focused. And, that, again, the green light would come from Ms. Pierce, not from you guys.
Yes, and little known fact, Diane Pierce only allowed us to have Harold's Chicken and Ice Bar. She didn't really like the name. She just, honestly, she just.
Little did she know.
Yes, but what she does agree normally is Harold's Chicken and Bars, and she likes that name. But
Okay, not the ice part.
But she allowed us to have it because we built that brand for
Okay.
Chicago.
Thank you.
Yes, sir.
Sorry, Mr. Kenner, back to you.
No problem. Now, Ms. Ruff, the name of the business that you and Ms. Robinson started was Harold's Enterprise LLC. Is that correct?
Yes, sir.
And the lady from Chicago allowed Harold's Enterprise LLC to operate at that location, operate the Harold's Chicken and Ice Bar at that location, correct?
That is correct.
All right. She did not mandate that only you or only you and Ms. Robinson could operate a Harold's Chicken and Ice Bar at that location. Is that correct?
That is not correct. She absolutely, it was only for me and Bobby only. And her words, that if any of our interests was going to be sold, we had her and Bobby and I
Objection, Your Honor.
had to agree to it.
Objection, Your Honor, this is hearsay.
That
Okay.
is not hearsay, that is absolute facts that I spoke
Okay.
to Diane.
All right, I bet you did, but we're gonna have,
That's considered, okay.
I mean, it's what she said, so it doesn't mean, the objection is not that what you're saying is false. It's just the person who said it is the one who need to say, here's what I told Ms. Rutherford.
He asked the question.
Yeah,
He
What did he
did,
say?
and this person has objected. You too could have objected. I know you didn't want to because you like the answer, but we've got three parties here. And as much as your theory is Pym and Robinson are perfectly aligned, they're not in this instance. And so it's a valid objection, and I'm going to take it for what it's worth. It was hearsay, but I understand the point Mr. Kenner was trying to make. Hold on one sec, and then I'll hear from you.
Yes, sir.
No more questions, Mr. Kenner, about what Ms. Pierce might have said to Ms. Rutherford. Yes, ma'am.
I would love for Mr. Kenner to give Bobby Robinson on the stand because she had a conversation with Diane.
Okay.
So because she knew what was going on, she did make it very clear to Bobby.
Well, if we're going to do that, your lawyer is going to have to agree that we're going to meet again because we're out of time and we're not going to be able to hear from Mr. Pym. We're not going to be able to hear from Ms. Robinson. I did a bad job, I guess, of communicating to the sides that this was not an all-day affair. But Mr. Kenner, back to you for a few more questions.
Let me hurry up, Jan. It is undisputed, Ms. Rutherford, that in the emails, well, we know in an email that you sent to Mr. Pym, as well as in text messages that you communicated with Ms. Robinson, that you indicated that you wanted a smooth exodus from the business. Is that correct?
According to that email on December the 21st, I did.
And you also said it in text messages to Ms. Robinson that you wanted a smooth exodus, correct?
That is not true.
So you
Text message that is that we're speaking of is when Bobby came to me via text, because all of our communication is through text thread. She spoke to me about cutting corners, cutting out. First, she wanted us to cut our pay. And I told her that instead of us cutting our pay first, that we needed to cut some things in the business. I gave her a list of those things, which totaled $6,000, which cut my pay $2,000 of those dollars, and then the others were cleaning, paying her.
I understand that. If I can, but I'm just
Let
asking.
her finish.
Paying her cousin $2,500, which included a total of $6,000. And I talked about the smooth exodus. She said that she liked that idea, but before we do any of that, she wanted us to cut our pay. And we went back and forth. And so then she said, so you're saying that you're not agreeing? I said, no. And I repeated myself by saying what we should cut first before we cut our pay all the way together. And she said that was not going to be a good decision. I will regret it. And in return, when she said that, when it came down to shutting the business down, or no, not paying the rent is what she asked, I told her payment plan, and then she spoke about us not giving, us not paying ourselves is reason why we're right where we are right now.
Okay.
So it's
I-
just being
I-
chastised.
I'm sorry to cut you off, because I don't have a lot of time. But are you saying that you did not mention in the text message that for whatever reason, you wanted a smooth exodus?
Yes, I
Yes or
did.
no? Okay. And you know what exodus means, correct?
Absolutely.
All right. You wanted to leave the business,
Well,
correct?
yes, well, sir, hold on, Mr. Attorney Kenner. The reason why I made that smooth exit statement is because at that time, Cameron Pym did not tell me that he was not gonna buy me out. So I was still moving forward to the agreement until we actually were official, no longer going to be Harold's Enterprise. That is the reason why I made that comment.
Okay. I just want to be clear. You wanted, at some point, you wanted to leave the business, correct?
Once I received my $450,000, yes.
Okay. Now, you had access during the month of December to the bank statements and the bank records and the bank account. Is that correct?
That is correct.
All right. You also had access and has always had access to all the records, bank records, whatever records that the accountant had, you had access to that regarding the business, correct?
In reference to the financials that he did every month, yes.
All right. And you have never been locked out of any access to the bank records, the bank account, where you could not have paid any type of expenses regarding the business in December. In other words, you could have paid it, correct?
Yes, we never
Okay.
got to the point of just really talking about what could have been done. She just outright just wanted to disassemble the business.
Well, let me say this. Let me ask you this.
Yes, sir.
When the landlord indicated that you all were behind on rent and that he was going to dispossess you all from the premises, you could have cut a
Let
check.
him finish.
Yes, sir.
You could have cut a check to the landlord to pay the rent. Is that right?
That is correct.
You
Now,
chose not to.
that is not, I did not choose to. I was still trying to work on it. First of all, we weren't 30 days late. We were only a few days late, and I'm not making light of that. It was just a few days. It would be different if we were 30 days late going into January, and then at that point, yes, we were officially would be 30 days late. From having a relationship with Cameron and talking with Bonnie, it was something that could have been discussed. She was not open to discussing and trying to get the rent paid. I said pay, but she asked me. I said payment plan. She disregarded it and moved forward with the decisions that she wanted to do. And that was to disassemble the business.
Is that in writing anywhere? What you just said, is that in writing?
Absolutely, it is in text message.
Okay, and you have access to those text messages?
Yes, because it was just her and I texting from the whole, from the time of when she called me a thief about the alcohol, we did nothing but text thread. That is it.
Okay. Now, it's true that Miss Robinson put $10,000 of her own money into the business during the month of December in order to sustain the business. Is that correct?
That is correct, and I also put $15,000 of my, of the credit card that was solely in my name. So we both put money in. The difference is I have to still make payments on it. The difference for her is she waited till she got all of her 10,000 back. So if we didn't have any money and we still weren't profitable to make anything coming in, we were still selling chicken dinners, everything, alcohol, everything. If we were that broke, how was she able to get her money back within a couple of weeks that she had just put it in? She waited till she got all her money back, and then she disassembled and said, hey, we need to just shut down the business. We don't have the money to pay the
Now,
rent. Anything.
I'm trying to speed you up. So you will agree that in text messages between you and Ms. Robinson, she indicated that you all needed to close the business. Is that correct?
Yes, sir.
And you will agree that in the text messages, she said that you all should get on social media and announce to the public that you were closing in December. December 31st is your last day, so that you can drum up business, get an interest in the community to pay off some bills. You will agree.
That is what she said in the text thread, absolutely.
Okay. And you will agree that you never contested any of those statements made by Ms. Robinson in the text messages. You did not contest it, did you?
I did not respond.
Okay. Now, the last day that the business operated was December 31st of 2024. Is that correct?
Yes.
All right.
But now
And
you do understand that Bobby and Cameron and I had already had this is not hearsay. It was discussed months ago, even with the architect, that we were closing the doors December 31. Cameron wanted the doors to be closed prior to that, but because of the permits and all of those things that needed to take place, it did not. And he was having some issues in reference to getting the finances. So there was a halt because Bobby and I were originally supposed to be purchasing the building from Cameron Penn. And when Cameron decided to buy my interest, all of that ceased, and Bobby and Cameron came together to make those decisions together without me. As a matter of fact, in November the 21st, November of 2024, the insurance agent, Debbie Ward.
Don't talk about what she said. You can talk about what Pim said. You can talk
Okay.
about what Robinson said.
Okay, yes, no, it was already planned for them to close down the business.
and you
It
testified.
wasn't because of the business not having sufficient funds.
You testified that the business was closing down for renovation, and that you were in agreement with that. Is that anywhere in writing between you and Ms. Robinson, or you and Mr. Pim? Mr. Pim? Is it what you just testified to, is that anywhere in writing?
Yes, it's in text.
Is
He
in the
said
text?
that, and I said, was the building still being, I said, are you declining your offer to sell, to purchase my 50% interest? Something to that, I have to go to the text. He stated yes. And I said, is the building still being renovated? And he said yes. So yes, I do have that.
Is that a
And
text?
the email,
Is that a text between you and Mr. Pim, or a text between you and Ms. Robinson?
text between me and him.
Okay, and have you produced that in discovery?
Have we done any discovery yet?
No.
No.
Yes, we
Okay,
have.
so no, you haven't.
Well, we've sent out discovery, written discovery, y'all. We have.
Okay, well, I know there's a motion to dismiss, but we're going to talk about scheduling in the time that we don't have. But I wasn't aware that discovery had been produced, so don't worry about that yet.
Yes,
The time may come.
All right. You understand that now you're saying that you don't have access to the bank account, but that bank account has been closed, correct?
Yes, she closed the account out.
And that was in January when it was closed, correct?
That is correct.
After you all had defaulted on the lease.
After we, excuse me?
Defaulted on the lease.
Yes, sir.
Okay. You said that you don't have access to social media. What are you talking about? The account for Harold's Chicken and Ice bar for the Edgewood location?
Yes, sir.
So are you saying that you do not have access to that? Is that it was is it Instagram, Twitter? What is it?
We have all social media platforms, Instagram, Facebook, TikTok. I don't have any of that. I don't have anything to the group me that has all of the information in reference to her making decisions, doing things. None of it. She took me out. Any email, Harold's ATL, Harold's Atlanta, all of those things.
Okay. So, but the Harold's.
There was a storage facility that was in my name that the business were paying. Even in January, I had to make those payments because they did not, which housed alcohol, which housed a lot of things I knew nothing of, that I was not given a key.
Okay. All right. I just want to make sure that Harold's Enterprise LLC is no longer in existence. Is that correct?
In my mind, it is, because she did not dissolve it correctly. I was not included and it was not discussed with me. She can discuss everything about paying the EIDL loan that we still pay. And when she texts me and say, hey, you need to pay this bill now or pay this, I Zelle her my portion and I say send.
Okay,
So
what is it?
there was communication where she could have actually said, hey, we need to dissolve the business. She never gave me any communication. She dissolved the business after she heard from my attorney speaking of the lawsuit. And then
Okay.
she went to properly trying to do the legal way and dissolve the business.
All right.
But in my mind, Harold's Enterprise, according to what I know, is still operable.
Okay, but it's not operate, Harold's Enterprise LLC is not operating at the Edgewood location. Is that correct?
That is correct.
All right. What irreparable harm in terms of things that are not, that you can't receive from some type of award from damages have you incurred?
Don't answer yet.
Objection, Your Honor. He's calling for a legal conclusion here.
The objection is calls for a legal conclusion. Your response?
Your Honor, is factual. She can give a factual test. She can testify factual what she is alleging in her motion.
Okay. I'm going to allow the question, but I appreciate that we have a business person. Are you a lawyer also? Not a lawyer. And so I'll consider the answer through that lens. Should he repeat the?
Yes.
Let me just ask you this. Let me just ask you.
Can you repeat the question, please?
Yes, let me just ask you this, maybe to streamline this. Is there any equipment owned by Harold's Enterprise LLC still left in the building, the Edgewood building?
No, she removed tables, she removed alcohol, she removed food, she removed tables, she removed chairs. The only thing that I would know, according to the Instagram visual, is the vent hood. I don't even know if that's still there. The tables, bins, seating, pictures, alcohol, food, air conditioning, the air conditioning is still there, the AC units.
Well, let me ask you, what AC unit, the AC unit, I'm sorry, the AC unit is owned by the landlord, is that correct?
It's owned by me because I paid for it. It's owned by Harold's Enterprise.
All right, well, let me ask you this. So the removal of the tables, chairs, alcohol, food, those things had to happen because you all were essentially evicted.
So wait till he finishes.
I'm sorry.
Those things had to happen. The removal of those things had to happen because you guys were legally evicted or so from the premises. Is that correct? You couldn't just leave it in there, so they had to be removed.
There was paperwork, but the eviction never was filed. So we were not legally evicted yet. Furthermore, I'm a 50% partner. So regardless if we were evicted or not, there was no discussion about what are we gonna do with this inventory, what are we gonna do with all of the things that Harold's Enterprise owned and came in together. There was never any of that.
Well, they're not using in the new business, they're not using to your knowledge, the tables,
that does
the
not
alcohol.
matter to me. You asked me a question. The question that you asked me was.
Man, let me finish the question, please.
Okay.
My question is, you're saying your counsel has indicated those are irreparable harms that can't not be dealt with through damages.
Well, that's hearsay. I don't know. I don't, sir.
All right, and let me ask the question, ma'am. Let me ask the question.
But you're making.
Stop. Let him finish his question, and you are free to critique it. You can say, well, you know what? You made this assumption that's not accurate.
Yes, sir.
And Mr. Kenner, we're going to need to wrap up.
I got you.
But that doesn't mean you can't ask her more questions. Ms. Rutherford's lawyers chose to call her, and so she needs to be subject to cross-examination. I'm gonna let you ask this question. If you need more, and it may be that you want to call Ms. Robinson and Mr. Withers may want to call Mr. Pym, we're gonna need to regroup because we're out of time. And so I am not foreclosing you from additional questions, but I'm gonna have to cut you off with this question, and then we'll talk a little bit about scheduling, okay? So ask away.
All right, so my question is, those things that you're saying that belong to Harold's Enterprise, the food, the alcohol, the chairs, the tables, those things had to be removed from the premises when you all were no longer renting there. Is that correct?
That is correct.
Okay. I'm going to need more time, Your Honor, when we can reschedule.
Okay. Ms. Rutherford, you don't have to stay there. You're welcome to go back to the table. Mr. Kenner, just since we were wrapping up with you, were you also planning as part of this proceeding to call now that Mr. Edge opened the door, if you will, to having testimonial evidence or evidence by calling Ms. Rutherford, were you planning on calling Ms. Robinson?
I have not decided yet, Your Honor. I will consult with my client and I'll let the court know.
Okay. And everyone should keep in mind, we are not trying the case through this hearing. All we're doing is establishing the elements that need to be met or just attacking the elements that need to be met for the issuance of a preliminary injunction. Mr. Withers, would you, based on what has transpired thus far, would you be planning on calling either Mr. Pym or Mr. Pinckney?
Your Honor, we would intend to call just Mr. Pym.
Okay. All right.
If further hearings are necessary or requested.
All right. So we do need to.
Your Honor, can I
Yes.
say something? If I can we make a motion at this point based on what the court has heard thus far?
So we're not going to do any oral motions right now. We're not going to do any argument because I'm not 22 minutes late for what I'm supposed to be on. But I do want the lawyers to confer based on what we've heard so far as to what the right next step is for the litigation surrounding the preliminary injunction, because that's step one. I also want you to confer about, we have a motion to dismiss that was filed and then renewed in the face of the amended complaint. And we do need to work through that. That, I believe, stands in the way of discovery happening. So we need to be mindful of that. As I look at the docket, the only motion to dismiss is from E3/Pym. There's not a motion to dismiss. I think that makes sense for Mr. Kenner. But it is challenging the allegations or the complaint against Pym and E3. I also am of a mind to say that the lawyers need to get in front of a neutral before we invest a lot of everyone's money in discovery. But I want to sequence these things the right way. And to me, number one is the motion for the preliminary injunction. Close behind it is the motion to dismiss, at least as to one defendant. But even if that were granted, I'm not saying it would be, we still have a lawsuit. We have a very active lawsuit between the primary combatants. And hence my notion that Mr. Kenner and Mr. Edge and Mr. Swift ought to be sitting at a table to say, is there a way to resolve this without investing a whole lot more of their clients' time and money? And there may not be, but this also was a situation which at one point in time was close to resolving with no court needing to be involved. But that fell apart. So what I'd like you to do is confer amongst yourselves and then get an email to Ms. Niles saying, you know what, really the next thing that needs to happen is we need another fill in the blank hours of your time, Judge, because we have to complete this hearing. We need to hear from Ms. Robinson, if that's what Mr. Kenner decides. We need to hear from Ms. Pym, Mr. Pym, and we got to finish the examination of Ms. Rutherford. Mr. Kenner didn't get to finish, and there may be redirect. Things may have come out on cross that Mr. Edge wants to follow up on. But the critical part is, and here's how much more time we need. It may be that you talk amongst yourselves and say, you know what, we don't need any, we're just going to rest on the record that was made and the legal argumentation that's contained in the briefing. Judge, please rule on that motion for preliminary injunction and rule on the motion to dismiss. We're not having a hearing on the motion to dismiss. Rule on that, and then we'll see what's still standing. Know that whatever's still standing would likely then start with, I want the lawyers to sit down with a neutral and see if there is a way to resolve this. And if that does, I don't normally order mediation, but I'm feeling it here. And so I will be if we're still going forward after we resolve those two motions. If that doesn't work out, and I'm fine putting that on a pretty short fuse, then we need to move forward with discovery and get going that way. Mr. Edge or Mr. Swift, any questions about that process I just described?
No, Your Honor. Sounds
Okay.
reasonable.
All right. Mr. Withers, Ms. O'Neill, any questions about that?
No, sir.
Okay. And Mr. Kenner, any questions about that?
The only thing, Your Honor, with the court, depending on how everything shakes out, after conferring with counsel, if we have to go forward with the hearings and the motion to dismiss, will the court entertain limited discovery regarding the motion to dismiss?
Why don't you all talk about that and put that in the email that goes to Ms. Niles? If everyone agrees, I'm not going to stand in the way of that. It just means I can take this off my plate for a while. But I can't say I've ever had a case where people say, wait, we need to do discovery for the motion to dismiss. That sounds like you'd be turning it into a motion for summary judgment. And that's not where we are right now. That's down the road some. So talk about it with opposing counsel and parallel counsel, Mr. Kenner, but I think you'd probably be saying it may need to be a motion for summary judgment. And I didn't know you necessarily had a dog in that fight, because as I'm looking at the docket, the motion to dismiss is PIM and E3 saying we shouldn't. It's basically what Mr. Withers snuck into his presentation here. Like, this really isn't, this is a messy situation for Ms. Rutherford and Ms. Robinson. Could we please stay on the sidelines and not be involved legally with this? The theory of the prosecution, if you will, is no, because there was this conspiracy. The only reason that Ms. Robinson had the wherewithal logistically and whatnot to do what's happening is because PIM, and not E3, but PIM was a part of that plan that divested Ms. Rutherford of her interest in this very, very successful business. So I'm not making anyone's case here. I do need the lawyers to talk about that. If your response to Ms. Niles is missing some piece that I need, we'll just circle back via email. But I know that in some respects, time is of the essence for Ms. Rutherford. I'm not trying to drag this out, but I want to make sure we get all the right pieces in place.
Yes, Your Honor.
So anything else, Mr. Edge?
No, Your Honor.
Mr. Withers?
No, sir.
Mr. Kenner?
No, Your Honor.
Okay. All right. Well, thank you, everyone. And I'll look for that email. The sooner you get it, the sooner to Ms. Niles, the sooner we'll be able to move forward. All right.
Yes.
Have a good weekend.
Thank you. Thank you, Your Honor.
Judge, can I approach the court reporter with the exhibits?
Yes, please.
I think the only